Good afternoon, everybody. I just want to welcome everybody to our Estates and Trust Study Group. We're about to get started with planning for potential litigation under the new elective share law. We have two phenomenal speakers that Ricky Adams will be introducing shortly. In the meantime, I just want to provide some brief logistics. We will be taking questions. You can send questions either to Angela Monroe via email address, which you should be able to see on your screen. It's angela@msba.org. You can also place questions in the chat box. So we will capture all of the questions and provide those to the speakers to be answered at the end of the program. If you have any other questions, technology issues, please also email Angela or put a note in the chat box as we'll be monitoring that. So with that, I will send this over to Richard Adams, who will be introducing our speakers today. Thank you.
Thank you, Anna, and thank you to the MSBA for putting this together. I want to introduce our wonderful speakers today. Kelly Prederati is a shareholder with Baker Donaldson, focusing in fiduciary litigation and resolution of estate and trust disputes. Jonathan Lastly is a member with Stewart Plant and Blumenthal, focusing in the areas of estates and trusts, charitable planning, and business succession planning. He is also the immediate past chair of the MSBA Estate and Trust Law Section Council. And I'm sure most of our listeners probably know both of these speakers fairly well. So I'm going to turn everything over to them. Thank you, Kelly and John.
Thanks, Ricky, and thanks, John, for being here with me. Back by popular demand, here we are talking about the augmented estate legislation. John gave a very thorough discussion to the group some point yet last year. I can't remember exactly which month it was, and I was thankful he did because he was put under fire with lots of questions. And since then, he and I, with three other colleagues, did a broader presentation on the augmented estate and new legislation for the MSBA in November. And I just want to point out that at the end of our slides, we have included a link with a coupon code which will allow you to download those materials for free, which I highly recommend that you do because they do a much deeper dive into things. This presentation is intended to be a spin-off, if you will, of that broader presentation where we will focus on areas of potential litigation, my favorite topic, and then Jonathan's favorite topic on how you can try and plan around to avoid the ultimate dispute. During this presentation, we'll go big picture, talk about a brief overview of how you calculate the augmented estate, the elective share, and things that need to be considered in order to reduce both. And then in the context of that discussion, we'll talk about potential areas for disputes to arise and potential planning opportunities to either avoid or mitigate them. So John, I'll turn it over to you to walk through the formula calculation. Next slide, please.
Thanks, Kelly. It's nice to be presenting with you again. Hello, everybody. So at the beginning, this is not going to be a deep dive into the introduction to the Act or the details of the Act. I just want to do a quick reminder on what the new formula is so that when Kelly and I talk about potential disputes in certain areas, you'll have an overall context. So as you can see on the slide, the new formula simply is the elective share equals the estate subject to election, which is an augmented estate reduced by certain things that we'll discuss, divided by 3 if the decedent has issue, 2 if the decedent does not have issue, and then the quotient of that is reduced by the spousal benefits, so that the remainder then is the elective share itself. Next slide, please. So the augmented estate consists of the decedent's probate property, revocable trusts, property in which the decedent held a qualifying power of disposition, and we'll be talking about that in some detail, the decedent's qualifying joint interests that we'll also cover in some detail, and the decedent's qualifying lifetime transfers, and we'll touch on those as well. As a reminder, under the statute, there is no double counting. Things are only in at their greatest value. That's in section 3404A2 of the new statute. Next slide, please. So the estate subject to election is the augmented estate reduced by the factors you see listed here, things you would expect: funeral and administration expenses, deaths, family allowances, and then certain types of trusts that aren't created by the decedent, or which benefit people with disabilities. Lifetime transfers made before the marriage or more than 2 years out. We'll be talking about that in more detail. Real property in which the decedent held a life estate without powers, and then certain life insurance policies. It's important to note that claims, et cetera, are enforceable against any part of the augmented estate, effect or reduction. And the consent by the spouse does not include gift splitting. We'll talk more about that in some more detail as well. Next slide, please. The final piece of the equation is the spousal benefits, which we will go over in some more detail later, but basically any property passing to or for the benefit of the surviving spouse upon the first spouse's death. So with that brief overview, we will now turn to some specific elements of this and talk about potential areas of dispute. So back to you, Kelly.
Thanks, John. Next slide, please. So when we began thinking about how to address the topical areas that could lead to disputes, we talked about the augmented estate as a whole, and then other issues that could arise in the context of reduction, payment, and valuation. So we've divided the presentation up in that manner. First, we're going to look at the issues associated with the calculation of the augmented estate, particularly focusing on what constitutes a qualifying lifetime transfer made by the decedent, what constitutes a qualifying power of disposition, and what constitutes a qualifying joint interest. And in the context of these, I'm going to give you some examples, as will Jonathan, which could at least start the wheels turning on where the disputes may arise, and then talk about some planning opportunities. And then we will shift gears and talk a little bit more about spousal benefits that correspondingly reduce the elective share, where value comes into play and how that can create potential areas of dispute, along with sources of payment for the elective share and waivers by the surviving spouse. Next slide, please. So let's start with qualifying lifetime transfers, because I tend to think that this is one area that is ripe for dispute on several different bases. I like to think about these first from a general perspective. What are qualifying lifetime transfers, and why do they get pulled back into what is the augmented estate? The general principle here is that you can't reduce the augmented estate by attempting to transfer an asset over which you retain an interest, or give it away for less than full consideration. And in the context of these, you think about inter vivos transfers during life and when they were made. In this particular instance, lifetime transfers are viewed contemporary, or from a time standpoint. When did it occur as contrasted to when the decedent died? And there's a 2-year look back period for pulling a lifetime transfer back into the augmented estate. In terms of thinking about maintaining an interest, you look at possession of property examples, income interest, annuity or unit trust interests, whether the decedent maintained the use and enjoyment of the property, and then additionally, whether the lifetime transfer also falls within another category, such as a qualifying joint interest, which does not have that 2-year time limitation, as well as qualifying powers of disposition. So when I think of qualifying lifetime transfers, I think of an instance where within 2 years of the decedent's death, they gave away something of value for no consideration or less than full market. So a good example of this is jointly owned property that's given away. And when you think of something that the decedent maybe retained control of, Jonathan and I were talking about an example this morning where maybe the decedent had valuable artwork. And prior to their death, they decided to give away that artwork to their daughter. And it was given away within 2 years of the decedent's death. And there's a couple different factual scenarios that can derive from this. If it's given to the daughter and possession is actually relinquished along with enjoyment and control over it, and it happens within the 2 years, it could still get, or likely would still get, pulled back in. A more interesting scenario is if you had a decedent who decided to gift his very valuable piece of art to his daughter, but then had to move in, or prior to actually giving it up, moved in with his daughter such that he hung that very valuable piece of artwork in his living space, despite saying he had given it to his daughter. I could see a potential for dispute to arise in that context over whether, if it had occurred more than 2 years, over whether the decedent continued to enjoy that and it actually constitutes a transfer. Let's talk a little bit more about what adjusts qualifying lifetime transfers, and to do that, I'll turn it over to John.
Okay. The important concept with qualifying lifetime transfers, I think, is the idea behind it is to make sure you can't disinherit your spouse by giving away your assets prior to death. So obviously things from that are legitimate deductions are deducted, claims and debts against the property. It's important to note that that would be claims and debts to which it was subject at the time of transfer, not at the time of death, unless it is somehow brought back in at its date of death value. Also, assets held in certain trusts and accounts for the benefit of disabled individuals, special needs trusts, those sorts of things may have been qualifying lifetime transfers, but Maryland public policy favors those, and so those are out. Arrangements to which the surviving spouse consented in writing. Again, we'll talk about consent later on and the details of that. Transfers made before the date of the marriage or within or later than 2 years before the date of death. Again, a temporal factor to say, all right, unless the gift is really made in contemplation of death, somebody's not giving it up there. So Kelly's artwork example, the decedent gives the artwork away to the child takes it to their house and is enjoying it in their house for more than 2 years, then it's out. If the decedent retains something in it or the enjoyment of it, then it probably would be back in. And then certain life insurance proceeds that are payable to close family members or charity. It's important to note those are only in excess of the cash value of the policy if it's a permanent product, or the aggregate premiums paid if it's a term product. So you can't use life insurance as a way to park value outside of the augmented estate. So with that background, we'll talk some about disputes, possible disputes under this, and back to Kelly.
Okay, next slide, please.
Oops, sorry, my bad. One more.
There we go. All right, so in looking at potential areas of dispute in the context of lifetime transfers, I think we'll see disputes over timing. When did the transfer actually occur? So go back to the artwork example. Maybe there is documentation reflecting the gift of the artwork beyond 2 years, but that the piece of artwork doesn't actually leave the decedent's possession for within a year of the decedent's death. There could be disputes over the timing. Also, as to valuation, which will be a theme throughout all of this in terms of potential areas for dispute, what is it worth when you're dealing with a special asset? And we'll talk about this more later. The actual value can swing widely in some instances, and so there could be disputes related to the valuation. And then retained interest. This goes back to the example that we were just talking about. Gifting is factually intensive, and the inquiry into it is factually intensive. So did the decedent retain the benefits? Did the decedent retain control? There are so many scenarios I think that we could see across the board where there are disputes about retention of control and benefits over the lifetime transfer. So John will walk through some strategies to try and address these potential areas of dispute at the outset.
Right. So the key thing in all of this is if to try to avoid the disputes is to provide as much certainty as you can. So the first step is that I would say, and I'm going to say this throughout, is to document these transactions as much as you can. Nail down the value. Make sure and have that recited places that you can confirm it, so that the disputes after the fact don't arise. Now, that's not going to be possible in every situation, but to the extent possible, that's the number one way to avoid disputes. Beyond that, obviously, obtaining the surviving spouse's consent up front is an easy way to handle this, and that needs to be done in writing. As I mentioned earlier, other than the writing does not necessarily need to be fully formal. It can't be a split gift consent, but other than that, some form of writing, the more formal, the better, I think, to avoid disputes in that area, would be desirable. But if you can get that consent, that then will take the asset out of the augmented estate. Another way to do that is to fund the elective share with other assets by using the spousal benefits. So the spousal benefits are a powerful planning tool under the new formula. You can't disinherit your surviving spouse, but you can plan around specific assets and find ways to make sure that the spouse is provided for at the same time that the larger estate planning goals with specific assets are taken care of. And then the final thing is, if you're going to be doing gifts and so forth, to the extent possible, avoid retained interests and so forth, because as we'll talk about in the succeeding areas, retained powers of disposition, retained joint interests can yank things that would have been qualifying lifetime transfers back into the augmented estate. So Kelly, any other thoughts there, or do we go to the next?
Yeah, no, I think that there are a few things I'd like to raise there. In the context of spousal consent, John pointed out that it needs to be in writing, but and the more detailed, the better. So a formal document signed by all necessary parties, probably the best. I could see a scenario where there's an email string between all the parties involved, the receiving party, the decedent, and the surviving spouse over a gift that's to be made, and whether the assent in an email chain constitutes spousal consent. You know, if I'm representing the recipient of the lifetime transfer, I'm going to say sure does. But if I represent the spouse, I'm going to raise authenticity issues and argue that it's not consent, and raise other arguments associated with that. So if your clients are planning to try and give away items that you think could subsequently be areas of dispute, agreed that the more formal the documentation, the better. And then in terms of the spousal benefits, I think that there are opportunities or potential areas for disputes to arise where you have family legacy items that, for all intents and purposes, were to remain in the family, maybe with children from a first marriage, and you have a surviving spouse that is part of the second marriage, and there, unless you plan accordingly, there are potentials, I should say, for the family legacy items to either be sold or be used to satisfy the elective share. So we'll talk a little bit more about that later. So let's move on to the next slide. All right, so qualifying powers of disposition. John and I think that this is an area that's probably less controversial when it comes to areas of dispute. But there's still opportunities for disputes to arise. So the general principle here is that you can't exclude assets from the augmented estate over which you retain control. So think powers of appointment, general powers of appointment, beneficiary designated assets, TOD, POD accounts, And then any retained power to affect the possession or enjoyment of property. An example of this, a retained power would be perhaps you give, the decedent gives a child a life or retains a life estate interest in the property with the balance going to the child, but then has the opportunity during the life estate to sell the property. That's a retained power to dispose of the asset. Let's talk about how the qualifying powers of disposition could be adjusted under the new law. Next slide.
Thank you. So with qualifying powers of disposition, a quick analogy there is Section 2036 under the Internal Revenue Code, for those of you who are familiar with that. So that if you think about that, that area of case law and so forth, you get a general idea of what may or may not be brought in. The adjustments are very similar in this case as they were to the qualifying lifetime transfers, claims and debts against the property, assets subject to the power in a trust not settled by the decedent. So, for example, if the decedent's parents set up a trust, give them a general power of appointment for generation skipping purposes, the decedent never funded the trust, never possessed the assets, that power is not included because the decedent did not create it. But if the decedent did fund that trust, say the parents set it up, but the decedent provided the assets, then the assets would be brought back in. Again, certain trusts for the benefit of folks with disabilities and special needs. Again, spousal consent, and then the life insurance, as we discussed before. So in this area, again, consent is important, and we'll talk some about the strategies and problems that can come up with this in the next slide, please.
Well, in preparing for this presentation, John and I spent a lot of time batting around hypothetical scenarios to try and think of the most poignant examples or just interesting examples where disputes may arise and where there may be planning opportunities. In the context of qualifying powers of disposition, one area of dispute that we talked about, giving an example of the nature of the power and the extent of the power, would be if a family business is involved and you have the decedent at the time that he died, if the surviving spouse is the wife, at the time that he died, he retained a voting interest in the family business, but had previously distributed it out beyond 2 years to his kids, the non-controlling interest in the family business. That there could be factual inquiries that will come into play in examining whether that voting interest that was retained by the decedent constitutes a qualifying power of disposition.
Right, and that's going to be an area of difficulty if the decedent wants to retain control over the asset. It's going to be hard to get it out without spousal consent involved. So form is going to be very important. The restrictions on the exercise of the retained power are going to be very important. Those are the types of things that you're going to need documented, but it's still going to be a facts and circumstances situation. Again, so spousal consent is the #1 strategy for avoiding this. And then again, if there's a way to fund assets, and we have some examples later in the presentation of ways to do this, to fund the spousal benefits in a way to eliminate the elective share, then you have more freedom of action with respect to assets like this.
Yeah, and to that point, John, when you have facts and circumstances that drive whether it qualifies as a power of disposition or not, I think that's where there are potential areas for litigation, because people will have disputing facts, there will have disputing positions, and the records related to the family business and how it was run and what voting control actually meant in the context that was retained could also be disputed. So Going back to the documentation recommendation, if your clients are retaining a controlling interest of a family business, you'll want to clearly document what their voting interest allows them to do, depending on what their goals are with that. And if they want to see that as not constituting a qualifying power of disposition, make them quite limited.
Correct, and that's an excellent point. And on top of that, it's also how the power is exercised. So you could have the best formal arrangement in the world, but if the decedent exercised it in a way that made the business or whatever it is, his or her personal piggy bank, odds are that's going to come back in because they were disregarding the form. So it's both the form and how how strictly that form is followed that'll determine whether or not it comes in.
Good point. Next slide, please. Moving on to qualifying joint interests. Here, the general principle is you cannot exclude from the augmented estate assets over which you maintain joint ownership at the time of your death. Now, the joint ownership will be correspondingly reduced such that the decedent only attributed the part at which he or she owned at the time of the death, or the actual value attributed to the decedent at the time of his or her death, but it still counts. Let's talk about the adjustments, and then we'll talk about a few examples where disputes could arise.
Yeah, and a quick piece of nuance to that. When you've got joint tenants with right of survivorship, the amount that's included is the greater of the decedent's fractional interest in that account, or the amount the decedent contributed. So if the decedent contributed 100% of the of a bank account jointly held with their child, the whole thing is in. If the child contributed 100%, 50% is in, because that's the decedent's fractional interest in it.
Well,
next slide. Oh, sorry, Kelly, go.
Yeah, before we move on, because I think you bring up a good point. That's a poignant example. So in the context of proof, when you're looking to a qualifying joint interest in the example of a joint bank account, remember, we don't have that 2-year time limitation with this category of assets. So this joint account could have been funded some time ago by either the decedent entirely or a blended contribution of the child and the decedent, but demonstrating the funding through business records or other evidence could be tricky, especially when you're dealing with bank records that typically are only retained for 7 years, and other documents retained by the contributing parties. So that's something to think about in the context of litigation issues. I'm not sure how you get around that other than actually planning to fund the share through something else, but it's something to consider.
Right.
Next slide.
So the adjustments here are quite simple. Claims and debts against the joint property, joint arrangements to which the spouse consented, and the same insurance arrangements if it's jointly held. So the problems here, as we'll talk about on the next slide, please, really relate more to sources and valuation.
Yeah, we talked just a moment ago about source of payment, and I can think of many scenarios to make it even more complicated. For example, if you have the decedent that has a shared bank account with his spouse and funds the joint account for the benefit of the child, and then you have to look at where the funds that came from the joint account came from. Similarly, valuation, if you're talking about step away from the bank account example, because that's pretty clear, although we'll talk about how that can change in scenarios where there's market volatility. If you're talking about a jointly owned property, like real property, valuation can have a pretty large swing when it comes to an appraiser's view of what the property's worth. So that could be a potential area for dispute.
Right. And so again, the key thing here, the best way to avoid problems here is document what's happened, how you've put how the sources of the funds, who contributed what and when. A lot of times that's not going to be available. So spousal consent is the first line of defense when it's not. And then again, as we'll show in the illustrations, finding other assets to fund things. So if you can make sure that the spouse is fully taken care of, you can zero out the share. And so that that's the best defense against many of these areas of dispute. Kelly, anything else there, or shall we move on?
Let's see. Now, I think we can move on to talk a little bit more about what constitutes spousal benefits.
Right. Okay. So as I said before, spousal benefits are anything passing to or for the benefit of the surviving spouse by reason of the decedent's death. Now, there's some cutbacks on that. So the spouse's share of any jointly held property. So, for example, if they own Black Acres, tenants buy the entireties. If it's worth $100,000, 50% goes into the augmented estate, 50% belongs to the spouse and does not count as a spousal benefit, where the decedent's spouse interest that was in the augmented estate does count as a spousal benefit. Property passing to or held in a trust that is not for the exclusive benefit of the surviving spouse during his or her remaining lifetime. The thought there is you don't want to have an arrangement that nominally puts the spouse as a permissible beneficiary of a trust along with children, and the spouse never sees a dime. That's effectively disinheriting them, and that's not permitted. Other trusts, however, that are for the exclusive benefit of the surviving spouse are permitted, but they're cut back because plainly the benefits are not quite the same. So a marital trust, a Q-tip trust, is reduced by 25% for purposes of calculating the spousal benefits, and any other trust that meets at least the standards of a statutory special needs trust is cut back by a third. The interesting thing about spousal benefits is the spousal benefits do not necessarily have to form part of the augmented estate. So, for example, if spouse owns life insurance on the decedent that is payable by reason of the decedent's death, that would be a spousal benefit. Similarly, a trust that might be brought in as a qualifying lifetime transfer, but was funded more than 2 years ago, also can be a spousal benefit if it meets the other requirements. So there are ways to, in essence, pre-fund the elective share under this. Basically, the bottom line is if you have as long as 1/3 of the value of the estate subject to election goes to the surviving spouse, you do not have an elective share. If you're using a Q-tip trust to do that, that means you have to do 44% of the estate of the estate subject to election. And if you're using, assuming there's issue, and if you're using a trust other than a Q-tip trust, it would be 50% of the estate subject to election is necessary to zero out the share. So, Kelly, anything to add before we?
Well, I think the issues associated with valuation of these trust assets could come up and create potential areas for litigation. So let's move on to the next slide.
Right.
Generally, in the context of spousal benefits, in the estate where the surviving spouse has made an election, there will be an effort, there will be sort of competing interests on valuation. The surviving spouse will try and downplay the value of the assets that he or she received as a result of the decedent's death, and the remaining beneficiaries or the beneficiaries of the trusts that John just mentioned will try and expand or increase the value of the spousal benefits because it correspondingly reduces what is left for the share subject to election, or the elective share. So in thinking through areas that could result in litigation, John and I talked about efforts to hide assets, and that is a good example of where discovery will be key. And we're going to talk a little bit more about discovery in the next slide, but just to point out that when it comes to learning what the surviving spouse received as a part of the spousal benefits, I think it will be very likely that formal discovery will need to be served. Otherwise, you don't really have a guarantee that you've gotten the full picture. And John, as a planner, you talked a little bit about this previously, just some ways to avoid the disputes over spousal benefits, which deal with pre-funding. But do you have anything else to add on that point?
Yes, I mean, use to the extent you're doing it upon death, use assets that are easily identified and easily valued, so that you can take some of these valuation disputes and is it or is it not a spousal benefit out of the equation. So outright dispositions or dispositions to a trust that is clearly a Q-tip trust or clearly meets the standards for the non-Q-tip trusts. And then use cash or life insurance policies or things that you're going to have to value anyway, interest in the home, retirement assets, those sorts of things. And then another approach is especially when they're inter vivos arrangements that you're hoping will count toward the spousal benefit, document them, and perhaps if you're concerned about it, write it into the document to the revocable trust or will, and say, I have provided spouse X, Y, and Z from other assets, so that it's clear what the decedent's expectations are for the formula.
Yeah, and I think in the context of the trust shares that will be used to calculate the spousal share, or sorry, the spousal benefit. Again, this issue of valuation surrounding the trust as a whole. We talked about the example of trust-owned real property, trust-owned special assets, family businesses held in trust that need to be valued. All of those things could be subject to dispute when it comes to the actual value. Additionally, we're going to talk more about this, but even especially in the circumstance that we find ourselves in now, when you're talking about accounts or trusts that hold marketable securities, there's a huge swing between what those securities were valued at 4 months ago compared to what they're valued at today. So we'll talk a little bit later in the presentation how to deal with those swings. But when it comes to an actual calculation, I think it's helpful to know the percentage that you need to apply to the trust to calculate it, but there could be disputes related to what the trust value is as a whole.
Agreed. And that goes to the point of, to the extent you can, use easily valued assets.
Next slide, please. Okay, so notice and information sharing. The legislation has notice provisions in it that didn't previously exist, and then it also has it provides for the availability of sharing information either formally or informally. So in the context of a surviving spouse filing an election, the spouse may, but is not required to give notice to the holders of non-probate property. So think of joint accounts that pass outside the estates, accounts that passed by way of beneficiary designation, trusts, anything that is non-probate. I would recommend, and I think John would agree, if you're the surviving spouse or you represent the surviving spouse, and you know of these non-probate assets, I would give notice as soon as you are able to do so. We also talked about what constitutes notice at our broader presentation, and I think that that's a potential area for dispute. The legislation says that notice must be in writing, but it doesn't specifically say what needs to be said or where it needs to be sent. So the idea that you could have this non-probate bank account, and typically the decedent would go to his or her local branch. If the notice is walked in by letter to the local branch, does that constitute notice to the bank for purposes of this legislation? Any thoughts on that, John?
The answer is I would think your latter scenario would constitute notice, but that's you might get a fight from the bank, and it's important to note that third party payors are not frozen in place. Basically, they're allowed to distribute assets to beneficiaries unless they have received notice. So in that case, if you're looking to freeze the assets in place, you want to make sure that they get real notice. So I would figure out work my way up the food chain at the bank and figure out who will guarantee me having delivered notice. This brings up a larger point that if you are representing a surviving spouse who thinks that she or he may want to make the election, that they're not satisfied with what they receive from the decedent's estate, you may want to file a protective election as soon as possible, because that then imposes a burden on the personal representative to notify the holders of non-probate assets that the election has been made. So that would help freeze those assets in place if there's any concern about trying to retrieve them later from the third-party beneficiaries.
Yeah, and I think that that's a good point. I mean, filing the election gives notice to the personal representative, trustees of any revocable trusts, and the person responsible for filing the estate tax return. One piece of the legislation that I thought was interesting is the addition of a notice requirement for trustees of revocable trusts. They're required to give notice within 60 days after they learn of the settler's death to the surviving spouse of the existence of the revocable trust. This is a notice requirement that's not captured in the Maryland Trust Act, where typically we find all of the notice obligations of the trustee. So it's something to advise your clients about who are serving as fiduciaries. The final bullet point on this slide talks about the informal or formal exchange of information needed to calculate the share, and vice versa, if there's access to information that the surviving spouse has surrounding assets, either probate or non-probate, or what they received at the time of the decedent's death for spousal benefits. Exchange of information can happen through the statute. I think, although I guess this remains to be seen, that request for information will be done formally through Title II discovery. The reason being, at least from my perspective as a litigator, I want a time frame. I want it clearly delineated first, the information that I'm asking for, but I also want a time frame placed on the response. And I think that there's no other real way to do that other than making formal discovery requests. Similarly, with interrogatories, the answers are going to be verified. So at least you have those responses being made under oath. Whereas if you just send a letter saying, tell me about all this stuff, you're not going to get necessarily the verification that you would with formal discovery. Anything to add on that?
Yeah, I agree with that, because I think most situations where this actually is going to really be coming up are going to be somewhat testy as between the spouse and the non-spouse beneficiaries. But there are going to be situations where it is just information and it may be forthcoming, and if it's satisfactory to both sides, then great. There's an informal method to do this as well.
That's a good point. Next slide, please. So we've hinted at the issues associated with valuation, but we want to dive a little more deeply into them now. So there are several areas that John and I see that could result in disputes associated with valuation. You have valuation of the augmented estate as a whole. You have valuation of spousal benefits used to reduce the elective share, and then you have the valuation of assets used to satisfy the elective share. So we're going to talk a little bit more about these concepts.
So next slide, please. So the basic principles used to determine the values of these various elements are: if there's a Maryland estate tax return required and the asset is includable in the gross estate, then it's going to be the estate tax value. If not, it will be the value determined under Estates and Trust 7202, which is basically how you determine the inventory value of an asset, whether or not the specific asset referenced is going to be included on the inventory or not. So those approaches hopefully are familiar to everybody and will be fairly accessible to practitioners. For the qualifying lifetime transfers, if there was a retained interest that did not expire before the decedent's death, it'll be the value as of the decedent's death. If the retained interest expired, it will be the value as of the date of expiration. And if there was no retained interest, it is the value as of the date of gift. And this goes back to the point I made earlier about claims or debts against that property transferred. If none existed at the time of gift, they won't be factored in. If they did exist, then there would be the property subject to the lien or subject to the debt.
So a good example of where there could be a dispute, and you can move to the next slide, in the context of qualifying lifetime transfers, if you think about an account that contains marketable securities that was made within the 2-year period preceding the decedent's death, if you're looking at the time of the transfer, it's worth one thing. If you're looking at the time of the decedent's death, it's worth another. So the concept of valuation in that instance, especially where there's market volatility, I think could result in people seeking judicial modifications of the valuations. Similarly, for inventory values, if you're dealing with real property, there's an opportunity to dispute whether the appraisal that was performed is accurate or represents the fair market value. So there could be disputes associated with that. I think that there will be competing interests throughout this if you don't have cooperative family members. And I agree with John that typically, although not always, if you have a surviving spouse making an election, there's likely to be high emotions involved and maybe discontent amongst the parties that survive the spouse. In the instance where when we're talking about valuation, you have the competing interest of the surviving spouse looking to see high values on assets that make up the estate to create a larger estate, which will correspondingly create a larger share, but then seeking lower values on assets that comprise the spousal benefits, which reduce their share. And then you have opportunities for other beneficiaries to try and see the elective share satisfied by a particular asset, but disputes over the value of that asset. And we were talking earlier about the valuation as a whole of trust and trust shares. I just mentioned the example of market volatility, but it's so poignant in today's market. I've never, or at least I can't remember a situation where there was this much swing in a week by week or day by day period. And so to the extent that it continues into the fall, which I hope it doesn't, that could be an area for disputes. And then we've talked throughout this about special assets and the tricky factors associated with valuing them, like family businesses. I think that could also be areas that are subject to dispute.
Right, and if there are disputes over an actual value and appraisal, there's not much you can do to plan around that. I mean, people are going to fight about the value of Blackacre or the value of the family business. They're just going to have to slog through that. But there are things you can do to perhaps mitigate the chances of that. Again, spousal consent and finding ways to make sure that there are other assets sufficient to fund the elective share under virtually all circumstances, because then that would take the whole valuation question out of the equation. But those true valuation issues, I think Blackacre is worth $100,000. Kelly thinks it's worth $200,000. That those ones, there's not a lot of ways to fight that one out.
I know, and John and I were talking about whether there could be an effort by the decedent to write in like who the appraiser should be of a particular asset and whether that would effectively reduce or limit the dispute. I don't think it would. I think it would still be something that surviving spouse or the remaining beneficiaries could contest, even if there was a direction that a particular appraiser be used for Blackacre. So again, going back to what seems to be the theme of all of this, it's pre-fund.
Pre-fund or get consent.
Pre-fund or get consent, that's right. So next slide.
Yeah. So the share it can be paid, and there are planning opportunities here. The share first gets paid, however the decedent says it should be paid. So if the decedent says, I want it paid from this asset, then those governing instruments will win as long as it funds with adequate value. Similarly, if the parties can come to an agreement on how the share should be paid, then that is fine. If neither that direction nor such an agreement is forthcoming, the share is paid first from the probate estate, then from any revocable trusts, and then proportionally from all the other assets that form part of the augmented estate proportion, or the estate subject to election, with a couple freeze outs. One, where federal law has preempted that. So, for example, a 401k, Maryland law can't reach that, so that's not a source of payment. And similarly, and special needs trusts also are taken out, whether federal law or under state law. A payor who has to make some of the payments has the option to pay with cash, a proportional share of each asset, or assets that are acceptable to the surviving spouse. So the first two mirror what's in the existing statute, but then there's, if they then can go to the surviving spouse and says, hey, I want to give you an interest in Blackacre instead of an interest in the business, and the surviving spouse says okay, then you can do it that way as well.
And I think just to throw in another example of a potential area for dispute when it comes to payment of the elective share, we talked about the payment of particular assets that maybe the surviving children thought were supposed to be left for them, like a family business or an heirloom, but that asset may be the only asset of value to satisfy the share. It might be.
Kelly, I think we're on the next slide. Sorry to interrupt.
Yeah. Oh, you're right.
Sorry.
It helps to have my guiding slide in front of me. So in the context of disputes over payments, I think that they could arise significantly when you have special assets, as we were just talking about, real property, family business, artwork. And what brought to mind the disputes that I began talking about on the prior slide was when you were talking about priority of payment and you go from the probate estate to the revocable trust, there may be a scenario where there's more than one revocable trust. And in that instance, I think it would be pro rata. Is that right, John?
Yes, I think so.
But then when you have the pro rata allocation, but you have different assets in each of the trusts, maybe brokerage accounts that are subject to market volatility or special assets within those trusts, there could be sub-disputes over what the value of those assets are. When it comes to order of payment, if we don't have clear direction from the decedent and the parties can't reach an agreement, there could be a real knockdown drag out over what gets sold first. So what are your thoughts on how to mitigate?
Right. So the first thing is to try to lock in values to the extent you can. So if you can move special assets out of the augmented estate or freeze their value by making a lifetime transfer of them and locking it in at that date of gift, then you're going to be able to mitigate these types of disputes as to what's coming where. And if you can get those special assets out, then they're not part of the estate subject to election. They won't be subject to the payment. And then Go ahead, if you've got special assets, provide instructions in the documents. Say, I expect that the spousal benefits will be paid from this source, the life insurance policy that's payable to the estate of the trust, or something like that, so that the chances of having to divide up that special asset, having to work out the value of it, are mitigated.
I think we can move on to the next slide.
Yep.
So now turning to the idea of waivers, both in the prenuptial and postnuptial context, as well as consents to specific transactions. Generally, a surviving spouse can waive their right to the elective share through a prenup or a postnup. And then the idea of the waivers that were signed pre-October 2020, if the language used was the all rights language referred to in the statute, it should suffice to adequately waive the elective share, even though the election is much broader now than when the surviving spouse signed the document. I still, Jonathan and I go back and forth over this. I still think there's the potential for dispute over whether there was adequate consideration for the surviving spouse to sign the prenup or postnup prior to October 2020 and have it be used against him or her after the legislation is put in place, because the estate, the augmented estate and the share that they're giving up is much bigger. But Jonathan likes to then revert back with the lottery example, where you could have been giving up your right to $500 million that the decedent subsequently won after the elective share was signed. I mean, after the waiver was signed. So creative parties will litigate if they have the opportunity, but I agree with you, John, that the all rights language should do it. And in our materials from November, I think Nakia Gray gave actual language that she was using in her pre and post nups. And so you can download that from the MSBA's website with the coupon code that's at the very end of the slides.
Right, and the specific, we mentioned earlier, the specific waivers in a number of areas. I don't think those require the same level of formality as a pre or post nup, but you want to make sure that the spouse was giving fully informed consent and just wasn't signing a piece of paper stuck under his or her nose at the dinner table. To make sure that those specific waivers or specific consents stick. Kelly, we've gone a little longer than we anticipated this far. Do we want to turn to questions and or do we want to go through the hypothetical real quick?
Why don't we try and blow through the hypothetical real quick? Because I think it will be helpful for people to see the calculations. So I'll just lay out the hypothetical. We'll run through the calculations fairly quickly, and then we'll jump to questions. John and I are happy to go to until 1:20 if people are willing and want to stay. If not, we can conclude after we take a question or two. So the hypothetical, next slide, please. The hypothetical scenario we have for you is that a man and a woman meet on a cruise after October 2020. They marry without a pre or post nup. Woman has 3 children from a first marriage and a family business. She gets sick, passes away within the first year of marriage. No new estate planning documents prepared after marriage. The existing plan leaves everything to the kids in equal shares. Surviving spouse makes the spousal election. Next slide.
So next slide. This gives a list of the types of assets that we're looking at. So we've got a little bit of non-probate, but the bulk of it is probate. Next slide. So the calculation of the share in this instance, what we take out expenses and debts, we end up with an estate subject to election of 9.3 million. There are children here, so it's divided by 3. So the elective share is 3.1 million. Next slide, please. So again, with no planning involved, the elective share is going to be paid from the probate estate, which means that the spouse is going to take, and we're going to assume there's not enough cash for the beneficiaries to cash out the surviving spouse. So the spouse is going to receive roughly 37% of each asset, including the family business. So the children all of a sudden have a new partner in the family business. Next slide, please. Okay. So one way to get around this is if the spouse did make a couple changes after the cruise, named the new spouse as beneficiary of her retirement plan and bought a bunch of term insurance. She would, in this instance, she would have needed to purchase $3.7 million worth of insurance to fully fund the share if that was then payable to the spouse. But as you can see, based on the calculation, the use of the spousal benefits, you can zero out the elective share. So in this instance, if the spouse made the election, there would be no share. The election basically would have no meaning. Kelly, any comment to that point?
Sorry, I couldn't unmute. No, I think you've covered it.
Okay. So next slide, please. So now let's assume that the surviving, the woman in this instance has a little more time to plan, does a little bit of that, wants to leave her existing plan in place, but also wants to make sure that the husband is provided for. So we're going to say she lives more than 2 years. In that case, she buys an insurance policy up front, puts it in an ILET, and so then it's so the premium paid is the qualifying lifetime transfer, but she lives more than 2 years, so it's out. So in that instance, instead of $3.7 million of insurance to fund the share, she only needs to buy $2.35 million again to fund the share, and she can do so exactly. So if you have the opportunity to plan for this and you do it on a formula basis, you could set up an ILET, for example, which would then be outside the augmented estate if you pre-fund it, and then say and you put extra insurance in there. You could then do a formula saying, I leave to spouse the amount necessary to fund the spousal benefits to produce an elective share of 0, and then have the balance go to other beneficiaries. Kelly, any thoughts there?
No, but I think it just continues to highlight the benefits of pre-funding if you can do it. I just, in reality, I think the people who are rushing into marriages and then not doing any subsequent estate planning documents when you have 3 kids from a prior marriage are also those that are probably not going to pre-fund their spousal share. But
correct. So then the final scenario, next slide, please, is one we touched on earlier, where in this instance, spouse has given away, and she doesn't actually need to, if she did this before the marriage, she has given away the non-voting interests in her business, but retained all of the voting interests. So theoretically, under this, the $750,000 in retirement benefits would be sufficient to almost fully fund the elective share. There'd be a $60,000 payment due. There would be sufficient cash in the probate estate to pay that. However, this scenario highlights the issue of qualifying powers of disposition and what we touched on earlier about the need for, would that retained voting interest be sufficient to bring the full value of the business back into the augmented estate or not? And that's probably going to be a facts and circumstances test based on the form of the power and how it was exercised.
all right, because we're getting low on time. Let's just see if we can blow through these last few slides pretty quickly. Next slide. Jurisdiction and authority. We talk about this in greater detail in our broader materials from the fall, but the orphans courts are vested with the initial jurisdiction over the calculation here. That includes jurisdiction over assets, at least for calculation purposes, to be paid, that the jurisdiction of the Orphans Court has actually been expanded in this case to deal with valuation over non-probate assets, and that's the point I was going to make. It also has the jurisdiction over assets from which the share is to be paid, so that's where this concept comes in. Typically, you couldn't get discovery on assets and valuation of assets that were not considered probate through orphans courts. And I think now you will be able to do so if the elective share has been exercised. And then in terms of authority, the orphans court is given power to issue orders necessary to determine the value and sources of payment of an elective share. So if the information needed to do so related to non-probate assets is not forthcoming, the orphans court will actually be permitted to issue orders associated with those non-probate assets and the valuation of same. They still don't have the ability to actually take over jurisdiction of those assets. And so I think that there are likely to be many instances where there is a transmission of issues from the orphans court to the circuit court if you're dealing with disputes over non-probate assets.
Agreed.
And I think we can probably skip the next slide or go quickly. It's just recites the current case law that was used to create the procedures and standards for judicial modification. And I suggest that everybody refresh their recollection of these cases because I think it's helpful in understanding the context. Next slide.
So the key final concept here is we've talked a lot about the formula and so forth, and as you've seen from the scenarios we've articulated today, no formula is going to work for everybody. The formula provides a basis, but a mechanistic application of it is just not going to produce equitable results in all situations. So the statute does provide the new section 3413 that enables the courts to step in and look at the value of the augmented estate, the value of the estate subject to election, the value of the spousal benefits, and the sources from which the share can be paid. There are a number of factors, next slide please, that the court may take into consideration. Those are discussed more fully in the presentation materials referenced on the final slide. So I will not go into detail on those now so that we have time to take a few questions, unless Kelly, you have anything to add?
The only thing I would add to that is that that the clear and convincing evidence standard was utilized, which is higher than or more than a preponderance of the evidence, but less than beyond a reasonable doubt. So I think it's important that the drafters and the legislature attributed that higher standard to the burden of proof because it will be more analogous to proving a claim of fraud.
Right. So with that, we have a few questions. Ricky, are you going to read those to us, or?
Yes, I will. Thank you, Kelly and John. It's very informative. We have a couple questions from the listeners. So the first one is, what does a spouse do in a situation where the spouse who would have consented to the transfer is deemed incompetent? How can anyone make the documentation valid?
I'd be happy to answer this. I don't think that you can. If the spouse is actually incompetent, unless there was a guardian put in place for the spouse, and then that guardian or a previously determined power of attorney then backed up the consent.
Agreed. And I don't think there's anything in the statute that makes the consent personal to the surviving to the spouse. So that I think a guardian or an attorney, in fact, would be able to act in that capacity, as long as it's not the spouse making the transfer.
Right, that's good.
And the second question is, do you need consideration for a spouse's consent as you would in a pre or postnuptial agreement?
I don't think so, but as I said earlier, you want to make sure that it's a fully informed consent so that there's no argument, oh, gee, I didn't know what I was signing later in the game. So obviously, the closer you can come to those formalities, I think the safer you will be. Kelly, do you have a different view?
No, I don't, but I would be interested to hear Nikia's viewpoints on that.
Agreed.
And
I believe,
to,
and I believe, as part of the annual meeting that's coming up on, we're hopeful that Nikia and another presenter will be able to talk some about the family law issues involved in this. That's still in the planning stage, but we're hoping it'll be part of the section's annual meeting in June.
Excellent. And there's a follow-up question related to that. What are some best practices for the consent agreement? Should it follow the format of a prenup, such as each side having independent counsel?
I mean, I think that ideally, everybody, if you can get that to that level of detail where you have attorneys involved advising each party of what they're giving up and what they're agreeing to, that's great. I think it's less likely to be that formalistic. But if you go to our broader materials from the fall, there are some consent examples that are built into prenup or postnup. I don't think we gave a consent to a specific transaction in there, but that I would also view as being probably less formal than what you'd see in a pre or postnup.
Agreed.
The next question is, slide 16 includes as a spousal benefit, quote, property passing to a trust in which surviving spouse is not the sole beneficiary during her lifetime, end quote. Is that correct?
Let me look at slide 16. That is not that is not correct. It should be that is actually the spousal benefit. The slide should read the spousal benefits are reduced by, and sorry, that's bad proofreading on my part. So.
All right, and the next question is, how can you assure the consent will be binding like a prenup?
I think you look for informed consent and full disclosure and proper execution.
Agreed. And the only way to be sure it's binding like a prenup is to use the form of a prenup.
Right.
Mm-hmm. Okay, the next question is, if a retained interest expired during a decedent's lifetime, why would it be included in the augmented estate? And then they point to the valuation principles on page 20 of the presentation.
So if the retained interest expired during the decedent's lifetime, but within 2 years of death, or so during the marriage and within 2 years of death, it would come in because it would be then a qualifying lifetime transfer and be brought in under those rules. The thought there is to prevent the deathbed disposition of assets. So, for example, the decedent creates a life creates a life estate and property, and retains the benefit of that, is living in the property, becomes terminally ill, and relinquishes the life estate at the last moment. That effectively is depriving the surviving spouse of assets that would be part of the augmented estate, and so therefore this brings it back in. Does that address the question, I hope?
I think so. The next question is, if you fund spousal share through retirement benefits, no offset for future income tax due as RMDs are withdrawn. Is that correct?
That is correct. It'll be date of death value, basically on the same concept as estate taxes.
Mm-hmm. The next question is, can judicial modification take place in circuit court?
I think the answer to that is yes. It can be transmitted to the circuit court. And that can be done by the litigating parties or the court itself.
Right.
The orphans court itself.
Okay, and the next question is, if this is regarding the hypothetical, if you create an ILET to cover the elective share and you make annual contributions to the ILET each year, does that bring some portion of ILET into a state subject to election?
The answer is yes. It would, to the extent of the premiums paid in within the last 2 years of life. So if those premiums represented 10%, say, of the total premiums paid, then 10% of the value of the ILET would come in.
And the last question is, what is legacy property?
So legacy property, and this is a factor that the court can consider in possibly adjusting the elective share. It is property that has perhaps passed down through a family for multiple generations. So, for example, a family home in which that the decedent owned nominally, but that has always gone from parent to child for multiple generations, or perhaps a piece of tangible heirloom property or something. The court can look at that and say, no, that's really a family asset, not really part of the estate. Again, a factor that the court can consider and determine the equities of the situation. It is not part of the formula.
And those are all our questions. Thank you very much.
Thank you for inviting us to speak on this topic. I think it's an interesting one, and one that will continue to develop.
Yes, thanks everybody very much for watching.
Thank you, everyone. The YouTube link is going to be also up with the recorded version of this. So if you've missed any part of the presentation, you can always view it on the msba.org YouTube channel. Thank you so much.